welcome to Social Media and the Law. I'm your instructor, Deborah Gonzalez. Now, today's session, we're going to be looking at intellectual property, the obvious and the notorious of social media. And as always, the way that I begin is this is for educational purposes only and should not be looked at as constituting legal advice. If you have a particular issue you want to seek legal counsel in that specific area. Now, this is the first of our sessions that's going to be looking at a particular practice area of law as it relates to social media and how social media has impacted it. Today we're going to be looking at intellectual property, basically copyrights, trademarks, trade secrets, and a little bit about patents. And then the second part of the session is going to be looking at defamation and publicity rights. Okay, so as we begin, as I always try to begin to have us all on the same page, when we talk about social media, we're talking about this communications tool and a way to disseminate information. We're looking at tools such as LinkedIn, Twitter, Facebook, and many others that are out there, including YouTube, Vimeo, and many, many more, including some book marking sites like Delicious. So those are the things that we're talking about and the environment that we're talking about. Okay, so first of all, when we talk about intellectual property, what we're referring to are creations of the mind, inventions, literary and artistic works, and symbols, names, images, and designs, and especially when these are used in commerce. Okay, so we're looking at what's being used out there, maybe sold, or there's a transaction for them, because there are many people who may create a painting or work of art and just keep it for them. We're not looking at that. We're really looking at those pieces that are out there in commerce. Okay, now when we think about intellectual property, there are actually two specific categories. The first category is industrial property. Okay, and this includes inventions. It includes trademarks, so think of logos, for example, industrial designs, and geographic indications of source. Okay, the second category is what we put under copyrights, and these are literary and artistic works, and they can include stories, poems, novels, films, musical works, photographies, paintings, sculptures, and architectural designs. And you're going to see that right in your handout, we've taken these definitions from WIPO, the World Intellectual Property Organization. And the reason why I took them from WIPO and not from the U.S. Copyright Office is because many of our customers and clients may be international in what they do, and so we want to make sure that when we talk about intellectual property with them, it falls within a definition that could be used anywhere in the world. So that's why I use the source of WIPO. Okay, in the U.S. in particular, copyright is looked at as a form of protection grounded in the U.S. Constitution. So this comes from our Constitution, and then it's granted by law for original works of authorship fixed in a tangible medium of expression. Okay? Now, there are some key words in there. Some of you may be very familiar, may even be practicing IP law. But for those who are not practicing IP law, I just want to go over some basic concepts. Number one, notice that it talks about original works of authorship. You know, the court does keep in mind that there might be that exceptional case that two individuals in different locations at different times can actually create something substantially similar, but if they created it on their own with their original thought, but not copying one another, then it's going to be stated that there's no infringement. Okay? Authorship, we're going to talk a little bit about who is an author and who is not an author, because it's not necessarily just the person who creates it, but then who owns the rights to that copyright in that item. The other thing is tangible medium of expression. One thing that you should keep in mind is that ideas are not protectable. This is one of the reasons why some of your clients might request, or you might recommend an NDA or a non-disclosure agreement when they're talking to a potential business partner or a potential vendor or someone that they might partner with, so that they do not disclose the information of what is being discussed in that conversation, because ideas are not protectable. And the example that I always give is, if you look at the movies, a lot of the plots are the same, right? Boy meets girl, boy loses girl, boy gets girl back. It might be girl meets boy, girl loses boy, girl gets boy back. But it's basically the same idea, the same plot in the story. What makes it protectable are the different details of that story, the setting, the time, the costumes, the actual dialogue. Okay, so again, ideas not protectable, fixed medium of expression. Okay? The next thing we should know about copyrights is that they're actually a bundle of rights. It's not just one, but a few of them. And these include the right to reproduce. So if you created an original, you can actually reproduce others of it, duplicates that you may then want to sell or give away as gifts, okay? But you can also sell that right to reproduce to a licensee or a manufacturing company. It doesn't mean that you have to reproduce it, but it does mean that you have the right to say who can reproduce it. So, and we get that through some licensing that we may do. You have a right to a derivative work. So in other words, if you create an original, you can modify that original and create something that's derivative, that comes from that base in the original. So you can modify that work and then get copyright in the derivative work as well, not just the original. But you can only create a derivative work if you have the right to the original work, okay? And this again is that licensing issue that becomes very important. You have the right to distribution, meaning that, you know, you can either sell it or rent it or lease it or lend it to somebody else. And that's also a very important right. The next right is the right to public display, and it's the right to show the work directly to the public. So if you have an art exhibit and show your paintings up there, or maybe show a collection of books or items that you have that right to display. And the last is a right to public performance, and this is the right to recite, play, dance, act, or show the work in a public place, or to transmit it to the public. Now, this public display right and the public performance right are really important online, because there's been a lot of cases that are sort of, well, if you display something online, does that then become a public performance? And are you violating copyright if you display it online and don't have that public performance right? And we have cases that go both ways, depending on how sophisticated the technology may be. And, you know, if, for example, we have something called cache in the internet. So when you bring up a website, it doesn't just physically come into your computer, it's actually brought into cache memory. So it's very volatile. It doesn't really stand in any place, it's just there. And so some of the courts have said, well, that is not a tangible, fixed mode of expression, and therefore, you know, there's not going to be a violation in that instance. But it all depends, and this is an area that if you are into technology, into media, and looking at IP, you want to delve a little bit more into those cases to keep that in mind. Okay? Now, what does copyright protect? When we looked at this a little bit before, original works of authorship, but you can take a look at this list of items that they have here, because what's also important is what it does not protect: facts, ideas, systems, or methods of operation, okay? Although it may protect the way these things are expressed. And a great example of this would be a business plan. Copyright would protect the written documentation of the business plan, but it does not protect the idea of the business model that's portrayed in the business plan. Okay, and that's a very important distinction, especially as we have our business clients who are trying to protect an idea before they actually bring it to market. They may have to do it through branding and trademark rather than copyright for some of these. Okay, another thing to keep in mind for us is, when is the work protected? And according to the U.S. Copyright Office, in the U.S., the item is protected at the moment of creation. Okay. So once you write that story, whether it's typing it on the computer, whether it's handwriting, once it's written, it's considered that it already has copyright protection. Now, this always brings up the issue, well, do I have to register it with the Copyright Office? Now, again, I just said it was automatic, right? Well, the Copyright Office says that yes, you have automatic protection, but you still want to register it for a number of reasons. One of them being that if somebody does infringe against you and you want to bring a case against that individual, you can only do it if you already have a copyright registration from the U.S. Office of Copyright, okay? The other thing is about timing. If you register your copyright within 3 months of publication, and publication meaning making it public, then what you do is you reserve the right to statutory damages that are in the Copyright Act. And this can be anywhere from $750 to $30,000 an instant of copyright violation, and usually given in cases where it's very difficult to determine what would have been the actual profit of that copyright violator in the infringement that they did. Okay, so copyright registration right now is about $35, but always check with the U.S. Copyright Office before you do a copyright registration to make sure you have the correct fees. But it is something that you want to talk with your clients, that if they do have a certain amount of intellectual property, that they may want to look at, if anything that can be copyrighted, that it is copyrighted, since it's only $35. It's relatively a small amount of money. Okay? Now, some other things to keep in mind about copyrights. The first one is this idea of public domain. Now, copyright's automatic without the need of putting that registration or that C. Lots of times you'll see the C in the circle that just specifies that it's copyrighted. And even though it's not required for items that are authored today, you may want to just advise your client to put it on, or even you put it on your website to just remind people that this material is owned by somebody, that this content is owned by somebody, even though it's not required. But what happens now if you have something that was created before 1976? There are some other rules as to whether there's copyright, how long the copyright lasts. You know, there was a time when you actually would get copyright for 28 years and then need to renew the copyright again for another 28 years. But one of the important things is to find out whatever content it is that you may want to use or that your client may want to use, but they did not create themselves, is whether it still has copyright protection, or if that copyright protection has run out and it has now become part of the public domain. And the public domain is sort of this concept of things that no longer have registration protection, and therefore people can reuse those items, put them into their work, okay, to create something new. And the public domain is really an important concept in copyright law, because the idea is that, you know, our artists, our inventors, our musicians, they do not just create something in a vacuum. They get a lot of input, a lot of inspiration. They have different muses around. And so there has to be a mechanism to let them be able to use those inspirations to a certain extent, okay? So one of the important things to find out is if your client or you are using content that you did not create, is it still owned by somebody, and who is that person? or is it in the public domain? So, for example, musical compositions written in the 1800s. The composition itself may be in the public domain, but be careful, because if it's been recorded by an orchestra in recent times and put on an album, the sound recording is not in the public domain. Just the music, the composition is in the public domain, but not the sound recording. So keep in mind also in what format you're getting that content in. And this brings us to the issue of appropriation. Now again, in music, you'll see this a lot in what they call sampling, taking a few notes of a very well-known song and putting it into a new song. In art, it may mean making, best example would be a collage of mixed media, where somebody has taken pieces of postcards or magazines and put them together and made a new photo or picture using those pieces, okay? But this is, part of this works on the concept of the first sale doctrine. So in that mixed collage, the fact that that person, you know, bought the postcards or were given the postcards, has the postcards in their possession, they're theirs, that then they can manipulate it and cut it up and put it in any way that they want. And the last issue to think about with copyrights is not necessarily a right with copyrights, but an excuse or justification for violating copyrights, and that is the fair use exception to copyrights. And this is the idea that copying that information was actually justified under one of these exceptions. And so something like that would be for educational purposes. It may be for criticism, okay? So if you're reading a book and want to do a book review, you may take little excerpts from the book to put into your book review, but not the entire chapter, for example. There is a 4-pronged test for fair use, and the courts look at everything from how much was taken to what the value was to how what was taken was actually used. And so these are things that you can look up and get much more detail into that area of fair use. Probably fair use comes up a lot, and you may have seen a couple of articles in terms of parody and fair use. But we did have a scenario in the latest political elections where some of the campaigns were actually using music from a particular song and changing the words, and they claimed that that was fair use. The courts actually came down and said, no, that was not parody, that was satire. Parody is when you make fun of the original, and that's protected. Satire is when you use something to make fun of something else, and that is considered violation, infringement of copyright. So you want to make sure you know the difference there, okay? Okay. So one of the things that becomes very important in intellectual property is actually who is the author. And sometimes this can be a point of contention for the simple reason of another concept called work for hire. So sometimes it's not necessarily that the creator created something just for them, but they may have been commissioned or contracted to create the item or write the review or create a logo for somebody else, another entity. And so we have to distinguish between an independent consultant or contractor and an employee who is considered that whatever they create within the scope of their employment that then belongs to their employer, or even a commissioned work. And sometimes with commissioned work and independent contractors, even though they may retain the ultimate copyright, within their contract they may actually be giving an unlimited and unrestricted license to the person who has hired them to do this work, if indeed it does not specify that it's a work for hire and that all the copyrights belong to the person who has hired them. So that's something to keep in mind, especially as your client or even you yourself might be having a graphics designer create a logo or create your website and the look and feel. You want to make sure that you still own the copyrights to that, or at least have an unrestricted license to do whatever you need to do to use those items to help promote your company or your product. So it's something to keep in mind. But then that brings up, well, then who owns a Facebook post or Twitter tweet or things that have been crowdsourced? We know that Twitter, for example, donates all of its tweets to the Library of Congress, okay? So Twitter has decided that they own the tweets and they can give it to the Library of Congress. But that license that they have does not restrict the person who wrote the tweet from then doing something else with the tweet if they wanted to, okay? As for a Facebook post, Facebook says that those accounts belong to the individual who has the ID. And this is why it is very important that if a company, your firm, or your client have employees who are doing things on a Facebook fan page, they want to make sure that Facebook fan page is an account to the company and not to that individual employee. That's very important so that the company can stay and own those copyrights and be able to manipulate that forum. Okay. Now, these copyrights can be transferred or reassigned through a sale or a license agreement. These rights can also be split. So, for example, when you have an author of a book, he can then sell movie rights and he can sell play rights and he can sell those to two different individuals or entities. Okay. Rights can also be limited by time or by a specific geographic location. But they also depend on what country this item was created in or registered in. So what you might see is that artists or musicians or even inventors may register copyrights in the US instead of their own country because they think they have more rights in the US, or vice versa. Companies in the US may definitely register in other countries. Keep in mind that there is no universal, no global copyright. So if you or your client wants protection in another country, they actually have to register in that country. Okay, so think of a Microsoft who has this software who's in all these countries. They have to register in all the countries where Microsoft is sold, Microsoft Windows is sold, so that they can have protection. And this can be a very long, tedious, and expensive process. Okay, so just something to keep in mind. So when we look at violations of copyright, one of the things we look at is plagiarism, which is the idea of taking credit for somebody else's writing or pushing as his one own, and then infringement, again, violating one of the rights in the copyright bundle. Okay, now how does all this relate to the social media arena? Well, let's take a look at some very specific issues with intellectual property and social media now that we have that nice foundation in place. Number one, most social media platforms will actually have in their terms of use, okay, or terms of service, some clauses that deal with intellectual property. So, for example, when we post things on Facebook, there is in their terms of use this idea that's saying that because we posted, we then give them an unlimited, worldwide, unrestricted license to use this content as a way for them marketing or for other specific uses, okay? So we need to be very careful of what we put up there because we may actually lose the copyrights to it. And this has happened to a number of musicians who may have put up complete songs on some of these social media sites and then find out hearing that their song is being played somewhere else and they're not getting any money because it was sub-licensed through one of these social network terms of use. So be careful with that. Another thing to keep in mind is the DMCA, the Digital Millennium Copyright Act. And this is very important because this has the safe harbor provision. And the best case to bring up that shows about the safe harbor provision is the Viacom versus Google case. Now, Google owns YouTube, and what had happened was on YouTube, certain users were putting up episodes of TV shows and movies that are property of Viacom. And so Viacom sued Google for copyright violation. The court came down that Google, YouTube, actually fell within the safe harbor provision as long as they took down any offending material once they were notified. So as soon as YouTube was notified that there was this infringing material, they took it down. And the safe harbor rule says as soon as you take it down, you're okay. okay? But if you left it there or you knew that it was infringing and didn't do anything about it, then you have a problem. So there is something called the DMCA takedown notice, and there's a procedure. So if your client believes that they have some of their copyright information on one of these sites, there's actually a procedure to go through in order to get that information down, okay? Now, Twitter has actually automated that procedure. You can see it right online. If you go to Twitter and just search, infringement or how to report an infringement, it'll take you to an actual page so that then you enter the information, you enter what your copyright registration number is, and they will then go through the process of taking it down. Now, the other thing this brings up is what we call the Creative Commons license. And this is a movement by some intellectual property creators to say, you know what, we're not going to charge you for using our materials. We want you to actually use them and reuse them, but we then don't want you to charge for using those materials in any way that you've created a modification or a derivative work. And it really does work on an honor system. So this is something you may want to Google Creative Commons license and get some more information if you're not familiar with that concept. Okay. One of the other things that has come up is this idea of, can you resell a used ebook? I think I talked a little bit, mentioned before, this idea of the first sale doctrine, right? You go out, you buy something, like I buy a book, a regular hardcover book, like one of these. I buy it, I bring it home, I read it, and then I decide, you know what, I've read it, I don't really need it before. I'll go and I'll resell it. I'll take it back to the bookstore, I'll sell it to a friend or whatever. And there's usually no problem because of the first sale doctrine says, I own it, I bought it, I have it, it's mine, I have the possession, I can then sell it. But what about an ebook that gets downloaded into this device? Can I then resell that? Well, there are lots of questions for the publishing industry about that idea of whether it can be resold, or if in fact the electronic version is just a license to read that book, but not necessarily a sale of that material that can then be resold up ahead. So just keep that in mind, that that's going to be an issue that still has not been determined, but is brewing out there as the publishing industry becomes much more digital and electronic going forward. Okay. Now, don't think most of these laws, like the copyright laws and these laws that we've been talking about, are pretty old. I mean, they've been with us since the formation, basically, of the U.S. So, it came out in the Constitution. But there are some new legislation that is coming out that gets proposed, and we have two in particular, one in the House of Representatives, and this is called the SOPA Act, S-O-P-A, and that stands for Stop Online Piracy Act. And this was brought to the House of Representatives by Lamar Smith, who's a Republican from Texas, and a bipartisan group of about 12 initial co-sponsors. And then in the Senate, we have the Protect IP Act. And what's interesting about these bills is that there are people who are proponents for it and people who are against it. And those who are for it shouldn't be a surprise. We have the Motion Picture Association of America, the Recording Industry Association of America, the U.S. Chamber of Commerce in Hollywood. So you see that these are the people who are really creating the content, and they want much more stringent protections online, okay? But then what you have are those who are against the bills that are really much more about, the technology companies, the companies like Google and Yahoo and Facebook, the ones who sort of serve as that channel to get that content out there. And their concern is that these kind of privacy acts are going to start legislating and criminalizing even hosting the content online. And they say, you know what, these piracy acts, they're too broad. The DMCA, the Digital Millennium Copyright Act, actually suffices to take care of what's happening on online piracy. So these two bills are in there. They're in the House of Representatives. They're in the Senate. They still have not been passed. They're still in debate. But it's something to be aware of because they can very much affect the rights of yourself as well as your clients in this online arena. Okay, so now that we finished with copyrights, I want to change gears a little bit and I want to take us into trademarks. Now, trademarks are words or symbols used to identify a source in commerce, and this is really important. Notice it says to identify a source, okay, and that it's used in commerce. In today's world, we really see that in branding. So think of logos. A great example would be the Nike swoosh, right? If you see that swoosh, you don't even have to see Nike buy it. You just know that it's a Nike product, okay? We consider that there's a violation of trademark if and when customers are confused between the two marks because they may seem too similar. Okay, so that's when we have trademark infringement. One of the other things that you'll see is that with some logos, you may see a TM, a small TM after the logo, or you may actually see an R in a circle. The difference between those is that the TM just means that it has trademark, right? Also automatic. Trademark, it becomes valid at the time of use in commerce, okay? Unlike copyright, that it's automatic at the moment of creation. But that R in a circle means that it's actually been registered with the U.S. Trademark and Patent Office. And that is a different process than the copyright. It's a lot more expensive as well. Copyright, we were talking about $35, you know. Trademark right now is running about $350 a specific class or category, and it can get much more expensive because of some prior searches just to make sure that the mark is valid to be able to be registered. One of the things to take a look at trademark, because it's so connected with branding today, is the idea of how it affects a reputation of a company. So I want to give you this example of what they call delusion or diminution of the value of a trademark, meaning that something has happened, an association has happened to that trademark that makes it less valuable in its reputation. And so some good examples of this actually have to deal with Facebook. Facebook had two cases. One was called Facebook versus Lamebook, okay? And this case was actually settled, okay? And the other one where Lamebook, basically what it did was it put up a disclaimer. Lamebook claimed that it was a parody of Facebook, but Facebook felt that that wasn't enough. And so part of the settlement is that Lamebook actually put a disclaimer that they are in no way associated with Facebook. Another one is Facebook versus Various Inc. That's the name of a company, Various Inc., who claimed that they were the Facebook for sex. Okay? And so Facebook again has this suit against them for using not as part of their name, but as part of their tagline, using that. Okay? Now, trademarks really help in social media. If you have your trademark registered, that actually gives you priority in terms of getting some social media accounts. So an example would be on Twitter. If you have your logo trademark and you want to get it as a Twitter account, and maybe somebody else has it already, but if they're not trademark registered, you can request from Twitter and submit your trademark registration information so that you can get that account. There are also lots of sort of abandoned accounts on Twitter, but they will not reassign the account name until, in fact, they have a request because of a legitimate registered trademark. So it's something to keep in mind. Another thing is we had a very interesting case that dealt with trademarks, domain names, and SEO. SEO meaning search engine optimization. Now, one of the issues of search engine optimization, the idea that, if you set up your website a certain way with something called tags, keywords that people will search to find you, then you will get higher in the search results that come out. Well, there has been a case that says you cannot use your competitor's trademark as one of your keywords because that would be considered anti-competitive practice. Okay, so you want to be careful that even if you or your client is doing SEO to their website or their social media sites, that they're not using trademarks belonging to others, because they can be held as infringing a law. So you want to be careful about that. Okay, I spoke a little bit about the XXX domain name and cyber squatting before, again with those trademarks. So you just want to keep that in mind. Okay, now as we move from trademarks, let's go into trade secrets. And the first thing that you need to remember about trade secret is that they're supposed to be secret. So there's no registration, as we saw for copyrights and trademarks. The idea is that it stays secret. And probably the best known, most famous trade secret is the Coca-Cola formula, and how whatever that ingredients of XX7, their secret ingredient, but nobody can know that because that's a secret, and that's the way that they keep it proprietary and internal, right? Trademarks has a certain extension life period. Copyrights has a certain life period, but trade secret lasts as long as you keep the secret, and it's the idea that this is proprietary information. Okay, so trade secrets you may also see as customer list or customer data that has been accumulated through a company's relationship with that customer or client, and that they're keeping that information. Okay, so basically, how do you get protection by trade secret? It's non-disclosure. You have to keep it secret and confidential. Okay, so an example that I want to bring up is one that a UK court actually decided, and it has to deal with LinkedIn connections. And this court decided that an employee who resigned from a company had to give over to the company all of his LinkedIn connections that were made while he was with that company. So they equated it to sort of the Rolodex that you build when you're working for a company, and the people and the clients that you were able to meet through them. So this UK court said that that belonged to the company. That was trade secret, that was proprietary information to the company, and that employee had to give those up. Now that leads to a lot of questions, right? Most people who are on LinkedIn may not have gotten all their contacts from just one company. They might actually have had it through their career as they moved from job to job to job. So does that mean then that they had to give it up every time and then reset or reconnect with individuals? So this is an area, again, that was a UK case. That wasn't in the US, but we're going to see how this is going to work out in the US arena. In the US, we did have that case about the Twitter account names, and I had mentioned that before, where an employee transferred, took a job with the competitor, and just changed the account name on the Twitter and basically took all 17,000 followers, or stole those followers to the competitor. And that case is still going on, but the idea is that yes, that was trade secret, and they need to give that account back, especially since the account name had the company's name in it. It wasn't just about the employee, but the company name itself. Okay, so that takes care of copyrights, trademarks, and trade secrets. The last area that we're going to go into in terms of intellectual property protection are patents. And a patent is basically a grant the government confers to an individual for an invention, and it's almost like a monopoly. That person is the only individual who can make that item for a specific amount of time. And you see this used a lot in the pharmaceuticals for their drugs, but also in inventions as we have there. So how are we seeing the apps? How are we seeing these patents come out with social media? We're seeing them in mobile apps, in technology of the handheld devices, in smartphones, in tablets, and in cloud computing. So this is really important, because even though it's not just on the user's end, if you have clients who are working on the technology and on the device end, you're going to see patents take a really big role on that. We have a case going on right now, Apple versus Samsung, in terms of the tablet, and patent infringement there on some of the claims. So it's going to be very interesting to see how that comes up soon. Okay, well, now that we looked at the obvious in terms of intellectual property in social media, now what I want to do is turn us to the notorious of social media. And what we're going to look at right now is defamation and publicity rights. So first of all, defamation is a state-level civil tort. And we have two kinds. When we talk about defamation of character, we talk about oral or slander, and we talk about libel, something that's written or published, okay? And there's basically three elements to determine whether there was a defamation issue. Number one, was there a false statement? And here we have to distinguish between opinion and fact. And just having somebody say, in my humble opinion, doesn't necessarily mean that they can say whatever they want and not be held to have defamed somebody. The second element is that it had to be communicated to a third party. So not just the speaker and the person he was talking about, but somebody else had to be there, okay? And the third element is that this false statement had to then cause proven harm to the plaintiff, to the person who's complaining about it, okay? So a false statement communicated to a third party which caused harm that can be proven to the plaintiff, okay? So one of the important things is who is saying what and where are they saying it? And this is very important in the social media environment because many times companies will have forums. And we'll take as a quick example the Facebook fan page. And on the fan page, you can actually encourage your fans to leave comments or to respond to things that maybe your company has announced or something that's going on in the world to make a general comment. If you allow these third-party postings, which are called user-generated content on the forum site, it's really important to have guidelines as to what can be posted and what cannot be posted so that you or your client are indemnified from maybe a defamatory statement that this user has put up, okay? In one of our first sessions, we talked about disclaimer policies and we looked at the CNN community guidelines and how they address this issue of defamation and how they say that it is inappropriate, it can be illegal, and then they have the right to take down that post. And that is very important that when you have these guidelines that you let your users know when and if you may take off a post if you consider it illegal or inappropriate, okay? Now, when it comes to defamation, truth is considered an absolute defense, okay? Now, there are lots of defamation cases due to Twitter, and I had shown one in a previous example by Courtney Love, who tweeted the name of an attorney that she had and that she was very disappointed that that attorney had been bought off. And this was an accusation that the attorney had been bribed. That was not provable. And so the attorney brought up a defamation suit against Courtney Love and won over $400,000. So we see those things that even though Twitter only has 140 characters, it can still present a lot of problems, especially if it's a false statement about someone. One of the earliest examples, and this is from 1895, and it's in your handout, just to show about truth as a absolute defense, is we have the Marquis versus Oscar Wilde. And Oscar Wilde basically brought a libel suit against the Marquis, and because the Marquis had insulted Wilde as a sodomite in public. Well, during the court case, it turned out that the Marquis was actually correct, that Wilde was a homosexual and did have those kind of relationships. And so actually in this case, Wilde ended up going to jail. The Marquis did not have to pay anything on defamation. So before putting in a defamation case, if your client feels they've been defamed, make sure you find out the facts, the complete facts, and that there's no truth in that supposedly false statement that came out. Okay? We also have another case here. This again was in the United Kingdom in 2010. And a law student actually filed a libel case against a former friend because that friend put up on the Facebook posting that this particular law student actually was collecting child pornography. Now, there are certain issues when it comes to defamation that are just considered so grossly bad that the court will call them, an infringement against that defamation of character automatically. And so you have to be very careful if there's anything at all related to illegal activity, like, for example, child pornography. So in this case, the law student won because it was an illegal activity, child pornography, and he had nothing to do with it. It was completely false by his former friend, not his current friend. Now, in another instance, now this was in the U.S., remember that was a UK case. In the U.S., we actually had a case where a teacher sued a student because that student wrote on his Facebook a tirade against the teacher and how the teacher was bad, etc., etc., etc. Here, the court decided that this was protected speech. And I think one of the differences between this case and the other cases, this case was just talking about the teacher's skills as a teacher, about how that student thought the teacher wasn't a good teacher, etc., etc. But it did not accuse the teacher of any illegal activity or wrongdoing. Okay, so it was mainly the idea that this was the student's opinion about that teacher, and there is a protected speech in your opinion, again, versus that fact which we saw before. Okay. But because of this has brought up some additional issues in terms of defamation online. Well, what about things like cyberbullying? Does that then become an illegal activity? And in many states, what we're seeing is that more and more states are passing legislation, anti-bullying legislation, that then includes a piece that sort of gives attention to the cyber or the online bullying component. We have lots of schools who are looking at this issue of anti-bullying and what rules they need to put into place, okay? Now, in the workplace, we also have the issues of cyber harassment and cyber stalking. So when are comments put up by employees about other employees, when is that considered defamation, or is it just a little harassment? And harassment based on discrimination is illegal. And so that can be brought up as evidence. These postings on these social media sites can be brought up as evidence in these cases. So we need to be aware of that. And of course, versus if what I'm saying is just protected speech in First Amendment, as we saw in that case with the student and the teacher, or is it not? Is it something beyond protected speech? Okay. So these are all issues that we need to look at in terms of what's being posted and written up against others. It was very interesting. We had an article in the New York Times recently talking about some of these social media sites and what's happening in smaller towns where people are actually using them to spread gossip and sometimes malicious gossip. And they're looking at what's happening at this phenomenon, because in small towns, everybody really knows each other. So even if you don't say someone's name, you may still be able to identify that individual, and individuals who are claiming that they're being harassed now and have to move out of that town because of things that are said online that may or may not be true. So it's really interesting to see where that is going. Okay. Now, the next issue that we're going to look at, that's the defamation, is I want to look at publicity rights. And what a publicity right is, it's the right of an individual to make a commercial or financial windfall from their identity. Okay, so it really protects a person's commercial interest in their identity. Now, this is a state-regulated law. This is not federal. It is not recognized by all states, and some states will only recognize certain factors of an identity versus others. So for example, in Georgia, most states, they'll recognize that you have protection in your name and in your likeness, the way that you look. So if somebody takes a photo of you, they just can't go and put it on a billboard to sell cigarettes, for example, if you have not given them that permission. In California, they expanded identity to not only include your name and likeness, but also your voice, your signature, and any photograph that's taken of you. And in Indiana, they've also included a distinctive appearance. So if somebody always wears a certain type of hat, that would be protected in Indiana. A gesture or a mannerism. Okay, so you can see how the states really have different levels of protection. Now, what's also interesting about the publicity rights is that in some states, this can be inherited. It could be passed down to the next generation. So if you look at estates such as the Michael Jackson estate or the Elvis estate in Graceland, or even Albert Einstein's estate, there are companies, entities that control those publicity rights and then will license them to, for example, marketing companies who want to continue to market using the image of that particular celebrity, even though they are no longer alive. So there's still a lot of money being made off of their likeness, off of the fact that they were so famous when they were alive. So you do have to keep in mind when it comes to the publicity rights, the idea of, how renowned are you or your client if this is their issue? Are they a public persona that people know, or are they a private persona that people do not know? Private individuals do not have as much of this right as celebrities or politicians, for example. In the Twitter environment, we do have a concept called Twitter jacking, which is the idea of individuals going in and sort of impersonating a celebrity and creating a Twitter account for that celebrity under that celebrity's name, even though they have nothing to do with that celebrity. And we had a very interesting situation. It was not a case brought up, but a situation that occurred that has to deal with, well, what about fan fiction? People that really like a certain show or book, for example, and then want to do some sort of creative endeavor connected to that. And a good example would be the AMC show Mad Men. And there is a particular character in there, and a woman who really enjoyed watching Mad Men and watching this character. She opened up a Twitter account as that character, and she started tweeting as if she was that character, thinking, what would that character say? Now, AMC, there was actually not only her, but about 3 other individuals that were creating these Twitter accounts based on these Mad Men characters. And AMC first sent them a sort of cease and desist. Stop what you're doing. These characters belong to us. You cannot just, tweet as them because you don't know our storyline. AMC wanted to control much more of their creative property. But what was interesting was that later on it came out that this was actually posted on one of the blogs, that AMC was coming down so heavy-handed on these individuals who were doing it not because they were getting paid, but because they loved the show and they wanted to continue, the whole ambiance of that show going on. So AMC ended up writing back to those individuals, letting them get their Twitter accounts reinstated with the understanding that AMC would be monitoring what they were saying, and if something was considered not at level with the show, that they would then take it off, okay? But AMC made that decision that they were going to encourage this kind of fan fiction through the Twitter because it was garnering them so many followers and so many people, viewers, watching that show, okay? And just a few last points that I want to point out in terms of intellectual property and defamation and publicity. Number one, right now, intellectual property is really, in the digital space, is really on an honor system, okay? We have no technology that can monitor everywhere, every time somebody copies something from somewhere else, okay? So that's something very important to keep in mind. So if you own intellectual property, it is your responsibility to monitor it on social media. Nobody is responsible to do that. There are no IP police out there. It is your responsibility. If you don't monitor it, you lose your rights, okay? The other thing is that we have to educate ourselves and our clients that there are these rights out there in social media, that they're online, but they still exist. And just as we have those rights others have those rights. So we want to make sure our clients know not to copy and paste from other sites and other social media entities, but instead to link to those sites and ask permission to be able to use some of that content. Lots of content creators don't mind if you reuse it or you link to them because they want the exposure, but you do need to ask for permission first, okay? And especially if you're doing any kind of blogging, if you're referring to other things, make sure you do it through links. Do not cut and paste. Very bad. When you're talking to your clients, when you're looking at IP and social media, it's not the idea of trying to deter people from putting IP out there. It's trying to educate them to limit your exposure and your liability. I mean, that's basically what all this is about. And you know, there's a very famous saying out there, if you want something, oh, there's an app for that. Well, you know what? When it comes to IP and defamation, there's insurance for that. And it's something that you need to discuss with your clients or even yourselves. Does your current liability insurance cover things that happen in the online environment to make sure that this is not something that's going to really cost your client or yourselves beyond what you can afford? But you want to check your insurance policies and see if they cover these kinds of things. There are cyber liability insurance policies out there as well, and it may be something, if your client is big enough or has enough exposure and presence out there, for you to have that discussion with them as well on that issue. Well, okay, as always, we've covered a lot of ground in a very short amount of time. If you have any questions, please email them to me, and I look forward to seeing you at our next session. Thank you.